Good morning, everybody. Thanks so much for attending today. This is another great session on a legal matter that a lot of people have questions about, how to avoid probate. This is part of our 2022 Secrets for Successful Retirement series. My name is Tara Kendrick, and I'm here with Bill Witt. We have our attorney that is supposed to be presenting today. Unfortunately, he had a court session that he could not avoid missing. So we will miss him, but we will give you great information today. All right, so how does Senior Resource Center help? Well, we help in 4 different ways. We do comprehensive retirement planning. That's looking out 30 years to try to see how we can best help you in retirement to not outlive your money. The second is tax planning. We don't do tax prep, but we do help people find ways to pay less tax in retirement. We also do a lot of long-term care planning that includes insurance products, also helping people protect and preserve assets and file for things like VA benefits and Medicaid. And then lastly, estate planning. Bill and I are not estate attorneys. That's why we partner with a great attorney like Andy Friedman, who helps us navigate those muddy waters. But we do advise families on, just ways that they can protect themselves while they're living, and then how to pass on assets when they're gone. All right, so if you've missed any of our previous presentations, these are the topics that we've covered. We've been working down the list since February. If you missed any of these and are interested in any of them, you can always go to srctexas.com and click on resources. And under that tab, there's webinar recordings. All of those that we've done in the past have been saved there, and you can always listen to them, pass them on to a friend, etc. So today's how to avoid probate. And then next week, we'll be talking about Social Security disability. And so if you know anybody who is struggling with this and wants to learn a little bit more about that, we'll also have a special guest to speak on that particular topic. All right, so that's all for me. I'm going to pass it on to Bill, and he's going to walk you through this awesome program.
Thanks, Tara. We're disappointed that Andy couldn't be with us. I've heard him give this talk several times. I'm going to do my best as a layman to kind of convey what he wanted to cover with you today. Everybody's situation is unique, so each of us needs different kinds of legal documents to protect our wishes. And while Tara and I can give general information, we're not attorneys, and we always tell people after we've had our general discussion, refer your questions to a licensed professional, licensed attorney to guide you. So what is probate? Most people think of probate as a process, court process or legal process that occurs after our death. And certainly probate does that. But as you're going to see in today's presentation, it also covers a wide range of other situations. Most people think of probate as a courtroom process where you take a will. People die, they have a will. Your executor or whoever you've appointed to handle your probate process takes a copy of the will to a probate court, files it, and then it's used to end up distributing your assets. And that's all true. But probate was expanded to include the administration of estates where there is no will. What if you die without a will and you have assets in your name? Somehow you have to retitle those. If you have an automobile, some property, possibly a homestead, how do you change ownership on those types of assets? Well, normally, what would you do? If you want to sell your car, you'd sign off on the title and you'd appoint a new owner. If you want to sell your house, you go to closing and you sign off as the seller. But, oftentimes we're not in a position where we can do that. We're either incapacitated but alive, or we've died. And in either case, we can't go and do what a normal person would do. And so the probate process helps through this type of situation. And it also includes, as I mentioned, the legal right or duty to care for another person while they're alive. And it's called guardianship. So probate, you have to think of it. part of it occurs after we die, but another portion of it can occur actually while we're alive. And today's presentation is to talk about what probate is, maybe some of the problems with probate and options so that you don't have to go through probate. So when does probate happen? Well, it can happen during your lifetime, and then it's called guardianship or living probate. And this is where somebody has become incapacitated. They can't make mental, medical, or financial decisions for themselves, and they haven't appointed anyone to make those decisions. So you own stuff, but you're not capable of managing it. So guardianship is a alternative. It's a way of the court appointing someone to actually help manage your situation. And then, as we think more traditionally, after death probate is where a will or someone who dies without a will, where their assets are going to be distributed after their death. So let's cover the living part of probate first. And Tara and I have encountered this, and I will tell you just very simply, our goal is to avoid guardianship at all costs. And you'll see there are a lot of costs associated with having to administer guardianship, where someone is appointed by a court to manage your assets or your personal decisions. Guardianship is a court overseen process, and there's two types of it, or two kinds. One is guardianship of the person, making decisions on where you might live, what type of medical care you might receive. And then separately, guardianship of your estate. You have assets, you have savings, you have property. Well, who manages those if you're not capable of managing them yourself? So there's two forms of guardianship. And so what is guardianship of the person? Well, it's a legal proceeding, and it's begun with a lawsuit with two goals in mind. And the first is to make an incapacitated person a ward of the state. We're not picking on somebody, but if you get to a point where you can't make your own decisions because of mental incapacity, such as Alzheimer's or dementia, or let's say you've had a traumatic brain injury and you're not able to make the normal decisions we make on a daily basis. Well, you can be declared incapacitated by a court, and you're in that point, you're made a ward of the state. And then a court also does a second thing. They appoint a guardian with the duty to care for you, the ward, to help make decisions on where you might live, what type of care you might receive, decisions about you as a person. The second form of guardianship is of the estate. Most people have savings, assets. You might have a 401k. You might have a home. You might have an automobile. You might have assets that were designed to provide for your care, but now there's nobody there to actually contact the custodian, tap the assets, and use those assets for your benefit. And so a court can appoint the same person as guardianship of the person, or a separate person to help manage your assets. Now, one of the problems here is the court decides who gets appointed. So you may have somebody making decisions for you you like, but it may not be the person you would have chosen. So what are the real concerns with guardianship? First, it's a continuous process. By that, there can be quarterly, monthly, or annual oversight of your situation. And by oversight, it means you're going into court. So whoever the court has appointed has to come back on a regular basis and report to the court what's going on. How are they caring for you? Where do you live? How are your assets being spent? Are they being spent wisely? And the court has the option to administer and manage that. Well, you can imagine, anytime you get a courtroom drama going, there are court fees. On top of that, usually there's lawyers appointed to serve as an intermediary between the guardian and the court. So you've got attorney's fees that can be very, very substantial. And then where it gets even more costly, what if you have parties with different vested interests? let's say a person is declared incapacitated and they have 3 children, and each of the children has different opinions as to how the incapacitated person should be cared for, how their assets should be spent. Now there's conflict, and the probate court will hear the conflict, but now more attorney's fees. So guardianship can be an incredibly expensive process. Uh, and there is a very simple alternative that we'll touch on in a few minutes. Let's talk about the more traditional role of probate. Most people think of it as something that occurs after we die, and probate does occur then. And it's a legal proceeding, and the goal is to transfer assets, transfer title on assets that you might have transferred while you were alive, but you didn't get around to it. The probate process is a public forum. It's not only conducted in court, but the records of the court on how assets are distributed are fully public. So this is a way of transferring assets after your death. But one of the downsides is unscrupulous people can go to court records and actually determine or look and figure out who you gave what to, how much you gave. And they can use court records to target heirs who have recently come into assets that weren't theirs, but they've inherited them. And, unscrupulous people can target those people and try to dupe them out or scam them out of the assets they've just received. So it is a matter of public forum, and a lot of people like to do things privately. Normally, probate follows one of 2 paths. It either follows the terms of your will, if you have one, or it goes through a process called intestacy, which means you died without a will. And what you're going to find is the state of Texas has a will for everybody, whether you have one or not. If you have one, great. If you don't, the state of Texas has a process of determining who gets what you've got. And one thing to remember is that probate only covers probate assets that are held in the name of the person that has died. Well, what do I mean by that? Well, if you've designated a beneficiary or identified who is supposed to get a piece of property or a vehicle or something after your death, probate has no control over that. It only covers the assets that were held in your name and didn't carry a beneficiary designation. So let's talk about the process. You can either die with a will, that's testate, legal term, or you can die without a will, intestate. Well, if you die with a will, it's based on the will, and that will name beneficiaries and heirs that are going to receive your property, your assets. If you die intestate, then the inheritance process is based on state law of descent and distribution. Legislatures years ago realized people die without a will, and so they created a formula that tries to pinpoint who gets what if you haven't taken the time to have a will and or to name beneficiaries. So it essentially creates heirs. Once again, your stuff may be going to people you wouldn't choose to give to, but it's using the state formula, not your own personal formula based on a will that you had drafted. So what's the intestate process like? Well, it's initiated by filing a will and a death certificate and an application with a probate court. And each county in Texas has a probate court. So you can go in and you file the will, you file the death certificate, complete an application with the court. Now, one thing Tara and I have seen over the last few years, which is troublesome, is you used to be able to go in and if you were a son or daughter, file with the court and essentially handle the process, the son or daughter dealing directly with the judge. But most counties in Texas today don't allow that. They want court efficiency. And so they require that the person bringing the will in, the death certificate, and filing must also bring an attorney. And what happens when you bring an attorney in? You start incurring a lot more cost. So after the filing of these documents, the court admits the will, makes sure that it was drafted properly and that it was notarized properly and witnessed properly. And then the court, after doing that, the court honors, hopefully, the terms of the will. And that means appointing an executor. Usually they're named in the will. If they're named as an independent executor, they have pretty much freedom after that point to distribute assets based on the terms of the will. So what does an executor do? Well, pretty simple. First, they have to gather or marshal the estate assets. What did the deceased person own? A bank account, possibly a vehicle or vehicles, land, homes, maybe life insurance policy, brokerage account, 401ks, all of these things. The executor's duty is to first identify what did the deceased person have. They then have to pay any outstanding claims. Maybe the person that died had some medical bills, or maybe they were paying on a contract, and so they have some obligations, and the executor has to honor those and pay off the creditors first. And then finally, their mission is distribute what's left. And they do that according to the will. They do that by identifying the heirs and sharing with them their portion of the will. Remember, all this is public record, so people can see what's moving to who. So what are the duties of an executor? Well, first, they have to notify all potential creditors and the community. And they do that. They post ads in the paper, and they have to notify creditors and community that the probate process is underway. If you have a claim, you have to come and make claim. They have to notify all will beneficiaries so that the people have the right to come in and hear what the will says and who's getting what. And obviously, when you get those people in court, sometimes you get will disputes. We've seen more and more of these in the last 10, 15 years where a long lost relative shows up, maybe a black sheep in the family, hears that mom or dad has passed away and that there's going to be a probate process. They show up in the courtroom and they can tell some very compelling stories, which can lead the judge to sometimes redistribute property based on that great storytelling, not based on the terms of the will. And then finally, they have to prepare and file an inventory of the estate. And this is a report that's filed back with the court saying, here was the inventory, here are the heirs, here's how I completed the mission and distributed the assets. And that's usually done without a courtroom hearing. What if you die without a will? You die intestate. Well, things get a lot more complicated. You still have to file with the court. So there's an application, and you have to file a death certificate with the court. But now there is no named executor, and the court has to appoint an attorney ad litem. This is somebody that will serve as the administrator to handle essentially what the executor was going to do. But it's a court-appointed person. And that person then publishes a citation. They publish an ad in the community in a local newspaper saying, we're probating the estate of the deceased person. It's going to take place on this date. If you have interest in this, time to be in court, time to make your claim. Dying intestate is considerably a longer courtroom process. Why? Because you don't have a will that identifies what the person had and who it's supposed to go to. So the administrator first has to start a lengthy investigation to find out what did the deceased person own. That can take a lot of time. It means digging through file cabinets, letters, mail, to try to determine what did the person have at the time of their death. And it definitely incurs much higher filing fees, usually much higher attorney's fees. I've worked with Andy Friedman for 18 years, and if he was here and I asked him, Andy, what is dying with a will and going through normal testate probate, what does that cost? And he'd probably say $2,000 to $3,000 in court costs and legal fees, because you've got to hire the attorney, they've got a function to perform, they have to go down and spend time in the court. If you die without a will, those costs go up dramatically. Why? Because there's more time in court trying to assure the judge that all the assets have been identified, all the heirs have been found, and that what's going on is correct and legal according to Texas law. Typically, intestate process, you're talking $4, 5, $6,000, much higher. Now, these are costs, whether it's testate or intestate, that can be, and Tara and I would recommend, should be avoided. So let's talk about some alternatives to the probate process. And the first one is incredibly simple. Everybody needs these. This is not somebody that's old and feeble. Everybody needs powers of attorney. There's two general types: medical power of attorney, that lets someone that you appoint make medical decisions for you if you can't make your own. As long as you can talk to the doctor and say, yes, I want that surgery, no, I don't, uh, you have the right to speak for yourself. But if you've been traumatized or have dementia and can't make medical decisions, a medical power of attorney allows one person to make decisions for you. And I say one person because Tara and I always recommend don't appoint dual powers of attorney, two people that act at the same time. You can appoint a series of people, but don't appoint a team of people or two people that act simultaneously. Why? Because generally they both have to be there to affect a decision. Maybe one power of attorney says dad needs that surgery. The other one says dad would never want that surgery. What does the doctor do? You're into a quandary. It's bad news. The second form of a power of attorney, which is equally and very important, is a durable financial power of attorney. Here you appoint one or more people in series, not in parallel, to make financial decisions for you. And your medical power of attorney and financial power of attorney might be two different people. Maybe somebody knows your medical conditions better, but someone else is more familiar with your financial assets. Having powers of attorney eliminates the need for guardianship. This is something everybody needs, not young, not old, everybody. Years ago, a friend of mine came to a meeting one day and his head was down, and I said, "What's the problem?" He said, "My daughter's a senior at University of Texas, and she's going into final exams, and she had a nervous breakdown." And I said, "Well, that's very bad. That's sad. I'm sorry to hear that." What happened next was even more problematic. He went to the hospital to make decisions for her. He was the parent. And they said, "Well, under what legal authority are you going to make these decisions? Do you hold medical or financial power of attorney to represent your daughter?" To which he said, "Well, no. No, I don't." So everyone needs powers of attorney. Hopefully they're never invoked. If they are invoked, you'll be glad that you put them in place. And that's while you're alive. And, we're living longer. We're seeing more and more dementia, Alzheimer's. These are documents, powers of attorney are vital. You want to do it now while you have the ability to pick the person or persons that you like to represent you. Well, what about after death? Number of options here. First one, and Andy would speak long and hard on this, trusts. Another way to pass assets after death is by moving assets into a legal instrument called a trust. And there's many kinds of trusts. What does a trust do? Think of it as a box, a legal box that holds assets. You no longer own the asset. I mean, you own it, but you've put it in trust. So the trust now is the owner, and the trustee might be you if it's a revocable living trust, or might be someone else if you've lost capacity to represent yourself. That trustee owns and can manage those assets. Since they're no longer in your name, they're not part of the probate process. And the trustee can then go in and distribute them to beneficiaries, to heirs privately. That's kind of nice. So the assets in the trust has a set of rules that say what happens to the assets after you die, and the trustee acts upon those rules and distributes assets without going through the probate process. So no courtroom drama, no challenge of the will. no public disclosure. All of it's done privately and efficiently. The second way that Tara and I strongly urge to all of our clients is putting as beneficiary designations on as many assets as you own. So, do you have a bank account? Well, then you jump down two more on my list: pay on death or transfer on death. That's another nice way of saying a beneficiary designation. I go to the bank and I say, if I die and there's no other surviving owner, like a spouse, I want my bank account to go to my son. I put a payable on death beneficiary designation on the asset, or a transfer on death. Different organizations, different custodians have different terms, but most allow for beneficiary designations. Well, what about your home? How do you put a beneficiary designation on it? Typically, homes, maybe vehicles, are the primary assets that always have to go through probate. Fortunately, there's two options in the state of Texas for a home. One is called a ladybird deed. You've listened to our earlier discussions on how to protect assets from long term care expenses. We've introduced the concept of a ladybird deed. And what a ladybird deed does, you still own your home. You can live in it, you can sell it, you can lease it out. You keep all of your current privileges. But a ladybird deed adds on a beneficiary designation. It names one or more people that get your property, your home, after you die. And so, once again, by putting a beneficiary on it, there's no need to go through probate for a court to appoint an executor and say who gets what. The beneficiary designation takes effect upon your death. What about a vehicle? Well, fortunately, our state has a what's known as a beneficiary title for vehicles. I own a Prius, a Toyota Prius. I can write up a beneficiary title and say, upon my death, I want my vehicle to go to my son. And he would go down to Department of Motor Vehicles, provide a death certificate, and ask them to bring up the beneficiary title that I filed, and they transfer ownership to him. I don't have to sign off on the title. Going back to houses, I mentioned there's two deeds that are available. One is the ladybird deed, which I mentioned. The other one is one known as a transfer on death deed. The legislature created these about 3 or 4 years ago to avoid probate. Now, Tara and I tend to favor ladybird deeds because not only do they avoid probate, but they help with something else, and that's Medicaid estate recovery. If someone has received Medicaid benefits, they're in a nursing home, the state's paid for their care, the state wants to come back after their death and get back from the sale of their home what it spent on care. The ladybird deed avoids that. So while both the transfer on death deed and the ladybird deed avoid probate, we know that the ladybird deed also avoids Medicaid estate recovery. So Tara and I are big fans of beneficiary designations. If you have a more complicated estate, a trust can be a very, very powerful tool, private, efficient, to transfer assets. Particularly, let's say you have property in multiple states. Well, you have to go to the state where that property exists to take it through probate, to change ownership. If I own property in 4 or 5 states, a trust can be the owner of that property, and now the trust handles all of the changes of ownership privately, efficiently. There's no need for me or whoever the trustee is to go to each county and go through a legal process there. Much more efficient. If you have questions on trust, strongly recommend you contact Andy Friedman. We've worked with Andy for 18 plus years. In fact, the reason we office where we do is because that's where Andy offices. I met Andy 20 years ago when I was starting this practice, and he had some wonderful ideas and he offered great help. He offers free consultations, and we just like him as an attorney. But there's other good attorneys out there too. And so, anyway, we moved our office here so we could be down the hall from Andy. So let's kind of wrap this thing up. There are two types of assets each of us has: probate assets that have to go through probate process if we haven't named a beneficiary, and if we have a will, or there are non-probate assets. Those are assets that are either owned by a trust or are jointly owned, so there's a surviving owner, or they have a beneficiary designation on them. Think of your IRA, 401k, maybe you have annuities that have beneficiaries named, and those assets are non-probate assets because you've already identified directly with the custodian who is supposed to get the assets. So, if Andy was here, he would toss in a little bit more recommendation for a trust. How can you distribute your property? Well, if you use beneficiary designations, you're giving them outright to a named individual, and that's okay. But that does expose the asset that the heir is receiving to their creditors. So your son or daughter inherits money directly through a beneficiary designation, and then a creditor or lawsuit comes after them and takes your inheritance away. Or there might be predator protection or self-protection. People sometimes can be duped out of their own assets. If they're held in trust, there is protection around those assets, and the asset transfer takes place privately. You leave assets to a son or daughter, and that child then goes through a divorce. Well, if they hold the asset directly in their name and commingle it with their own assets, that asset can be subject to a divorce settlement. Half of your money can walk out the door with your ex-daughter or son-in-law. So trusts can play a very essential part in protecting assets while you're alive and also after your death. If you have questions on these, once again, seek out professional guidance from an attorney. Wow, we covered an awful lot today, Tara.
Yeah, that was a lot.
I need to put my legal degree up on the wall, maybe. Andy would be chiding me on saying that. So if you have any questions, you can post those up at the top of the screen. There is a, what do you call that, Tara?
Talk bubble.
Talk bubble. And, the one question that came up, I think we've already answered. It was, how much does probate cost? And I gave kind of a general rule of thumb. If you die with a will and you go through probate, probably $2,000 or $3,000. If you die without a will, probably more like $4,000 or $5,000. Either way, it's a process that you can avoid if you take the simple time to have powers of attorney to avoid guardianship, and if you take the time to set up either a trust or beneficiary designations on your assets. In either case, you can avoid probate and the time and effort. You won't avoid it, but your heirs will.
Yeah, and if you have questions, legal questions, you're welcome to contact Andy Friedman. His information's on the screen. Same with us, just broad questions we're happy to answer. And then, of course, anything related to retirement planning, we're happy to answer. And like Bill said, both Lee and Andy always have free consultations. So you want to talk a little bit about next week's topic?
Yeah, next week's topic is an interesting one. We've not done this one before. Sadly, some people become disabled before they reach retirement age. And there's two paths to get them help. One is Social Security disability planning. And the second is they may have private insurance through their employer or through a separate policy that they can apply to get income while they're in a state of disability. And one of the things, Tara and I get a lot of phone calls. Hey, I've become disabled. Can you help me apply for either private insurance disability or Social Security? That's not in our wheelhouse, but fortunately we have many professional affiliates. If you get my book, and everybody gets a PDF of my book today for attending, and if you also would like a printed copy of the book, the 2022 version, just send me an email saying, Bill, I'd like a printed copy rather than an electronic copy. But at the back of the book, we list 20-some affiliates, professionals that we work with. And the one that we're going to work with next week is a legal team here in Austin, Bemis, Roach, and Reed. We're having one of the principals, Greg Reed, join us to explain the pros and cons of trying to do Social Security disability on your own. And let me tell you, there's a lot of cons. There are some DIY things in life, but trying to get disability benefits isn't one of them. You could be on your deathbed and Social Security will pretty much automatically decline you. You need professional guidance. And Bemis, Roach, and Reed, they're one example of the professional affiliates we have. So join us next week. I think you'll find it enlightening. If you have a friend, relative, neighbor that is experiencing disability, you're going to need some help. And the law firm of Bemis, Roach, and Reed might be a great asset. So with that, I'm going to sign off. Tara, anything else?
No, just look out for the email following up with the recording of this session, as well as the free copy of your book. And the hard copy, remember, is free. So if you'd like a hard copy, please let us know. And we will see you all next week. Thanks so much.
Have a great week.